lease proposal. Uh, Previously, I met him in a trade fair and I shared my card with him. I told him that our company was seeking to establish a factory in Bangladesh.
Was that gentleman Mr. Azan Rahman?
No, that was another employee from Fiscal Science Limited.
Mr. Anthony, in what capacity did you enter into an agreement with the respondent Fiscal Sense Limited?
As a representative of the Capital Connections Company Limited, I signed the agreement on behalf of the company.
Can you briefly describe the subject matter of the agreement with the Fiscal Sense Limited?
Sure, I can. The agreement involved sale of certain assets belonging to Fiscal Science Limited and the transfer of the lease plot numbered 346 and 347 located at Sonargaon Export Processing Zone.
Was there any negotiations or formalities done before entering into the formal agreement?
Yes, there are several negotiations taken place before entering into a formal agreement. This negotiation paved the way of providing advance money and signing a memorandum of understanding and also providing the indemnity.
Why did Mr. Azan Rahman give indemnity in his personal capacity?
Well, Azan Rahman provided personal indemnity to assure us a legally binding agreement as we have already paid them 60% advance without entering into any formal agreement. So it worked as a warranty for us until entering into any formal agreement with the Fiscal Science Limited.
Did you think Azan Rahman, the managing director, was more reliable and creditworthy than the Fiscal Sense Limited?
Well, the indemnity was given for a short period until entering the formal agreement. Considering his fame and reputation in the corporate world, we thought we could rely on him since Fiscal Sense Limited was a comparatively less popular company.
Is there any mention regarding such indemnity in the formal agreement?
There was no explicit mention about the personal indemnity given by Azan Rahman. The indemnity was given to avail under certain circumstances before entering into a formal agreement, but the indemnity wasn't invoked as no such occasion had ever arisen. Furthermore, we urged to incorporate Article 3, an article affirming our 60% advance by Fiscal Sense Limited. So, Fiscal Sense provided their consent, and Article 3.2 was included in the agreement, and also Article 6.1 supersedes and cancels all prior agreements and understanding, including the indemnity. So now it stands as superseded and cancelled by Article 6.1.
As per the agreement, when was the agreement decided to be performed?
As per my knowledge, Article 4.1 specifically states that the total handover and takeover shall be completed on or by December 2021. So it was December 2021.
Did the respondent, Fiscal Sense Limited, perform the agreement?
No, they didn't complete the total transfer within the prescribed time limit.
Did they ever show their genuine intention to perform?
Well, after receiving 60% advance from us, they didn't comply with NLC condition at the first place. And secondly, they just delayed the whole process by taking extension from us without communicating any sort of information about their disputes with WIPSA and Custom Bond Officer.
What about the claimant Capital Connections Limited? What measures have you taken before and after such non-fulfillment of the contract?
Well, before the deadline, we issued a default notice on 12 December 2021 to cure their defaults, as they didn't comply with BIPSA NOC conditions. However, even after issuance of such a default notice, they didn't cure their defaults nor complete the transfer. On top of that, we have allowed them extension for a long period, as our intention was not to repudiate the contract to perform it, as we have invested a lot of money and labor in this field. Finally, when we came to know about the auction procedure and Webza had already terminated their lease from the newspaper advertisement, we bona fidely asked them about the matter, as we were concerned whether the performance of our agreement was still possible or not. However, Fiscal Sense Limited didn't communicate anything to us to assure that they were capable to perform their part of agreement.
Why did your company issue a termination notice?
Well, as already stated, we didn't find any room to proceed with the agreement. Also, Bebza had already terminated their lease agreement, and also Bebza put those those plots in the auction procedure. So most importantly, they couldn't perform their part even after a long extension beyond the original deadline. So finally, we had no option left to us but to terminate the agreement.
Mr.
Council,
Anthony,
can I please intervene? Council, learned council, can I please intervene?
much obliged, your honorable
Uh,
arbitrator. Yes, you can.
yes, Mr. Witness, Mr. Anthony, right? You are.
Yes, Honorable Arbitrator.
Yes. Can I ask you one thing? Like, you are representing capital, if I'm correct, right?
Yes, Honorable Arbitrator.
Did you have any prior knowledge as to the fact that the bank accounts were freezed? I'm talking about the
Well,
response.
Well, initially, while we were negotiating and signing the memorandum of understanding, they didn't inform us anything. But when we have provided them 60% advance, then they communicated us the matter.
And even after knowing that thing, you executed an agreement with them on September.
Honorable Arbitrator, we have already paid them 60% advance, and they assured us they are capable to perform their part of agreement, and also provided us NOC from BEBZA. So we then saw a potential to complete the agreement. That is why we entered with them into a formal agreement.
Did you give them the 60% advance in a single payment?
No, Honorable Arbitrator. We provided the 60% advance in total 6 installments.
Six
4 installments.
4 installments. And at which point of time did you know that the accounts were freezed? Is it after paying the last installment or is it in between?
Uh, it was after paying all those monies.
So after paying all the installments, you got to know that
Yes, Honorable Arbitrator.
freezed. Okay, and after knowing that, you entered into the agreement with the other side. Am I correct?
Yes, Honorable Arbitrator, as I already have said, they assured us by giving NOC from BIBSA, and they showed throughout the whole procedure they are capable to perform their part. And they assured us they would solve the matter of frozen account soon.
Thank
Objection,
you.
Honorable Arbitrator. I have something to tell.
You will get the time when you will cross-examine. I'm almost done with this witness.
Thank you.
You're welcome.
Honorable arbitrator, with your permission, may I ask the last question to Mr. Anthony Davis?
Yes, please.
Much obliged, honorable arbitrator. Mr. Anthony, why did you participate in the auction procedure, and have you communicated it to the respondent side?
Yes, we did communicated the issue to Fiscal Sense Limited after publication of the auction advertisement in the Financial Express. And we participated in the auction procedure to secure the lease, since the termination of the agreement made it obvious that Fiscal Sense Limited wasn't capable of performing the agreement anymore. And after all of this, we tried to mitigate our losses by participating in the auction procedure so that the lease property didn't fall in the hand of a third party.
Thank you, Mr. Witness. Thank you, Mr. Counsel. We are done with this time frame.
Much obliged, honorable arbitrator.
You're welcome. Now it's time for the other side to cross-examine the witness, and I believe that you have been trying to raise an objection. What was the objection that you were trying to make back then?
Honorable Arbitrator, am I audible?
Yes, you are.
As witness has stated that about the account freeze, we have informed them after the agreement. This is not right. We have sent them in our exhibit that 31st December 2020 about the exhibit, in our exhibit, that our account got frozen. And on 3rd September 2021,
Where can I find that,
we
Mr. Counsel?
entered into the agreement.
Mr.
So
Counsel,
they
where
were
can I
aware
find-
of the
Mr. Counsel, can you hear me?
exhibit number.
Mr. Counsel, can you hear me?
A little bit of
Learned Counsel, can you hear me? Learned Counsel, can you hear me?
Honorable Arbiter, there is a technical problem, so our counsel is not audible right now. So give.
Learned Counsel, can you hear me now?
তুমি কি শুনতে পাচ্ছ না কিছু?
এখন পাচ্ছি।
বলো বলো বলো।
Learned Counsel, can you hear me?
Arbiter, am I audible
I can't hear you.
right now?
Learned Counsel, can you hear me? Can everyone else hear me?
Yes, Honorable Arbitrator.
Arbitrator, we can hear you.
Learned Counsel, can you hear me now? Learned Counsel.
During technical reason, Honorable Arbitrator, can you hear me?
I'm talking with the respondent side. I believe that you are in the same room. That might be a problem, you know, because there are some problems when you're in the same room with the network and so on.
Honorable Arbitrator, am I audible?
Yes, I can hear you now. Can you hear me?
Yes, Honorable Arbitrator, I can hear you fine right now.
In the process, we have lost 3 minutes. It's 3:47. Learned Counsel, you were talking about a letter through which you informed the claimant of the fact that your bank accounts had been freezed, right?
Yes, Honorable Arbitrator.
Where can I find that letter from your statement of defense?
Well, on our exhibits.
Yes, you have submitted me a 38-page document. Where is that letter that you are referring to? Can you hear me?
Honorable, yes, Honorable Arbitrator, on our exhibit number 3, you can see the email that letter we sent to the capital company about our account status, not only fiscal.
Page number, please refer to page number.
Page number 25.
Page number 25. The email is dated 31st December 2020. Is this the document that you are talking about?
Yes.
Is the problem from my side or is the problem with your side? Can everyone else hear me?
Yes, Honorable Arbitrator, we can hear you clearly.
Is this the problem with the respondent side?
My apologies, sir. During IT problems, we are facing some problems. So we'll take care of it.
Honorable Arbitrator, sorry for the problem. Can I proceed with my cross-examine with?
Yes.
This
Start.
Yeah. So, Arbitrator, on page 22, exhibit number 25, we have raised the concern about our account status, and not only to the MD of Capital, but also.
Learned counsel, I have gone through the paper. You now conduct your cross-examination, please.
Okay, thank you. Much obliged. Well, how long you have been the managing director of Capital Connections?
Well, still I'm managing director of the Capital Connections Limited.
Can you please let me know the time frame? And how
Well,
many-
I'm serving almost 6 years in this company.
Okay, and why did you prefer fiscal company over other companies?
Well, as I have already said, one employee from the Fiscal Sense Limited shared this sale proposal to me. And then we started negotiation with Ajan Rahman and the Fiscal Sense Limited formally. And then we find the plots suitable for our business venture.
Okay, and did you communicate about the installment that you were about to make to fiscal?
Yes, we have communicated.
And what was the communication? Can you please state for the arbitrator and everyone else?
Well, we have sent several emails while giving the advance money in 4 installments, and after providing money after every installment, we have sent emails to Fiscal Sense Limited to confirm us whether they have received or not.
Okay, according to your mails and conversations, you stated that after NOC you would be completing the other installments. But did you communicate with fiscal that even after getting the NOC from BEBSA, you would take 3 installments to finish the 60%?
Well, we have communicated the issue.
Well, I don't find any fact on your any exhibits that anywhere you have mentioned that even after getting the NOC from BEBSA, you would take more than 1 installment to complete the payment of 60%. Well, I am well aware of the fact that you will be you will proceed with your installment after NOC, and you made the first installment before NOC, right? But after
Yes.
after NOC, you took more 3 installments to complete the rest of the amount. Did you communicate with fiscal about this issue, that you would be taking 3 installments?
Well, we have provided them 3 installments and they received and confirmed us. So I don't find it relevant.
But there was no
any other now.
communication. Okay, there was no communication.
If there was any communication, how come they received those amounts?
No. Beforehand communication. Okay, as we are running out of the time, I would like to go to my next question. And when did fiscal send you the bank issue, the problem that fiscal was facing with the bank status? When did they let you know about their problem?
Well, so far I can recall, it was after signing the memorandum of understanding on 31st December 2020, I guess.
Right, 31st December 2020. However, is it true that you have entered to the agreement on 3rd September 2021?
Yes, we have entered into the agreement on 3rd September 2021.
Okay, then you were well aware of the fiscal bank's status before entering to the agreement.
Yes, as I have already stated in my examination of chief, we have entered into the agreement and after knowing the information regarding frozen account, since Fiscal Sense Limited assured us they are capable to perform their part.
But if I am not wrong,
Mr. Counsel, may I intervene?
Yes.
We are running out of time, but I would like to know from you, like, you are suggesting the other side that they had prior knowledge of the fact that the accounts were freezed, right? That is your suggestion.
Exactly.
Okay, and then you are saying they entered into an agreement with you in September 2021. Is that correct?
Yes.
My question to you is, why did you enter in that agreement well, knowing very well that your accounts were freezed?
Well, honorable arbitrator, we also informed capital about the illegal account freezing of our account, because we were having an issue with the custom bond officers, and they wanted the bribe, they want illegal money to resolve our status. But when we didn't allow, so there was a dispute going on. So we also communicate. Yeah.
Okay, I have taken note of your point. We are running out of time.
Yeah.
I am requesting the claimant to present their second witness.
Honorable arbitrator, I had a lot of important question. I would like to ask the witness. If
Yes,
you
but
give me just
I cannot.
additional 5 minutes, I'm sorry for the technical issue, but the questions are very important for the fact. If you allow me, just 5 minutes. I would just go to yes or no question.
Let me have a talk with the other side, with the claimant. Claimant, they're asking for 5 minutes.
Honorable arbitrator,
Do you have an objection to that?
Yes, Honorable Arbitrator, we raise objection to that because there has been an allotted time and they have conducted their cross-examination session. We feel that there is no requirement to provide them with further 5 minutes. This would exceed and overwhelm our witness in any way. So we humbly seek your consideration on this matter because there is an allotted time and that has been expired. Thank you, Honorable Arbitrator.
Objection upheld. You can, I'm talking with the learned counsel for the respondent. You will get this chance when you will cross-examine the second witness.
Well, arbitrator, can I plead for extra time in this witness because it's it's one of the key witness which is very much necessary.
Running out of time. We are running out of time. Please take note of the fact that like time is of essence again. And if you have anything to say, you can say this during your closing statement or during your opening statement. I will take note of that. Please present your second witness, the claimant.
Honorable Arbitrator, I would like to invite Counsel Urmi for the chief examination of our second witness, Adil Zubair Rahim. May we kindly have your permission?
Yes, please.
Much obliged, Honorable Arbitrator.
Thank you, Constable. Honorable Arbitrator, with your kind permission, the Council would like to proceed with the chief examination of the claimant witness number 2, Mr. Adil Zubair Rahim. Facts related to substantive arguments number 1B, that the respondent has failed. The respondent fiscal has failed to comply with the terms of the conditions put forward by the BEBSA in its NOC and the lease agreement with the BEBSA, and substantive argument number 5, that the auction held by BEBSA after the termination of lease agreement between fiscal and BEBSA was thoroughly successful, and it was held following the procedures, and the claimant participated in the proceeding in a bona fide. May we proceed, Honorable Arbitrator?
Yes, please.
Okay, Mr. Adil Zubair Rahim, can you hear me? Hello, Mr. Adil Zubair Rahim. Mr. Adil Zubair Rahim, can you hear me? Honorable Arbitrator, we might be having some problem with our witness. Mr. Adil Zubair Rahim, can you hear me? Honorable Arbitrator, as it seems, we might be having some technical issues with the connection of claimant witness number 2, Mr. Adil Zubair Rahim. Please take note of that, Honorable Arbitrator.
I'm taking note of that, but please also take note of the fact that I will not be able to give you an extension of time.
Yes, sir, Honorable Arbitrator.
Counsel, am I audible?
Yes.
Yes, Mr. Adil Zubair Rahim, you're audible. Sir, Arbitrator, may I proceed?
Yes, please.
Mr. Adil Zubair Rahim, can you please state your name and designation for the record?
Surely. My name is Abdul Zubair Rahim. I'm 60 years old. I worked as the project director at Bangladesh Food Processing Zone. I recently retired in 2023.
Your line is
Okay.
breaking. Your line is breaking. Is it just me who is facing this problem, hearing this witness?
No, sir, arbitrator, I'm also having some trouble.
Sir, arbitrator, my apologies. Please, counsel, proceed.
Please proceed.
Okay. Mr. Adil Zubair Rahim, how do you know about the respondent fiscal sense?
Well, I came to know about Fiscal Sense Limited when BEPSA entered into a lease agreement with the company in 2013 regarding certain plots, which was owned by BEPSA. Later, BEPSA signed a lease agreement with Fiscal Sense Limited in 2018, where certain plots were allotted to them via a lease agreement.
Okay. What is the status of the respondent during the term of the lease agreement? I mean, how did you find them? Did you find them compliant?
Well, the short answer would be no. The company Fiscal Sense Limited has been in default of the lease agreement for a long time, including non-payment of dues to BEPSA. Later, the company filed an application to grant them a no objection certificate, which was on in 2021. And after proper consideration, BEPSA issued that NOC.
Okay. In your witness statement, you mentioned that the respondent has been in default for a long time under the lease agreement with BEPSA. Despite this long default, why did BEPSA issue NOC to the respondent?
Well, yes, you would be correct, but the NOC was not unconditional. It was conditional as Fiscal had already committed defaults earlier. Two important conditions were outlined in the NOC. They would be Fiscal had to clear all outstanding dues to BEPSA, and they were required to observe the customs formalities that are generally observed by the seller and purchaser.
Okay. Okay, Mr. Rahim, can you describe the events that took place since the issuance of the NOC by BEPSA?
Well, after the issuance of NOC, Fiscal failed to comply with both the terms of the lease agreements and the conditions contained in NOC.
When did BEPSA terminate the lease agreement related to plots number 346 and 347 in the Sunargaon EPZ?
As per my knowledge, it would be 15 July 2020.
Okay. And what were the grounds cited by BEPSA while terminating the lease?
Well, BEPSA cited a few grounds, as far as I can remember. There was failure to complete the formalities of the selling procedure as stated in the NOC and non-payment of outstanding dues to BEPSA.
Thank you, Mr. Rahim. Did BEPSA conduct an auction for the leased property after terminating the agreement with the respondent Fiscal Sense Limited?
Yes, BEPSA did conduct an auction. Firstly, BEPSA published a notice of the auction back in October 14, 2022, and the auction was held in the following month, in 20 November 2022.
Okay, and where was this notice of auction published?
In a national daily called the Financial Express.
Okay, and what was the outcome of the auction? Was it successful?
Well, the auction was in fact pretty successful. I remember conducting the auction by myself. There were 5 parties and who participated in the auction, and BEPSA, Capital Connection stand out to be the highest bidder. The auction was held, as said earlier, in 20 November 2022, and later the possession handover certificate was provided to Capital.
Thank you, Mr. Rahim.
I intervene, counsel.
Sure, sir, arbitrator.
Please take me to the fact of freezing of bank accounts.
Oh,
Like,
okay.
what's your take on that? And what's the take of the witness on that?
So, arbitrator, our witness is a BEPS official, and the respondent Fiscal Sense Limited did send an email to BEPSA notifying that their account had been frozen illegally by the Customs Bond Commissionerate.
Okay. Do you want to add up like anything more on this?
No, sir. No, sir, arbitrator. We're trying to prove that the respondent Fiscal Sense Limited had always been in default with the lease agreement with BEPSA, and they also violated the NOC. Though BEPSA did give the NOC, they violated the two conditions contained in the NOC. We're trying to prove that Fiscal is in default.
Okay. And is there any view on the part of BEPSA regarding the fact that the respondent couldn't make the payment due to the fact that their accounts were freezed? I'm talking with the witness as well.
Sir Arbitrator, the respondent communicated that fact to BEPSA in February of 2021. So, can you please repeat yourself? Can you please repeat the question?
My query is, did that affect their ability to make the payment towards the lease?
Sir Arbitrator, as per my knowledge, the freezing of accounts it's not has not been found to be done in good faith. I'm not sure about that context as I'm a BEPSA official, but if there were difficulties, Fiscal was supposed to communicate with us at much earlier date. As per their claim, the account was frozen in 2018, and they communicated that to us in 2021, 3 years later. So I don't find.
So, Mr. Witness, I would just like to clarify one thing. That like you are saying that the accounts were freeze back in 2018, but you didn't know of that at the time of issuing the NOC. Am I correct?
Yes. Yes, you would be correct.
Back then, would you still issue that NOC?
Sir, as I wanted to mention one thing, that BEPSA has done business in good faith always, and they do not believe in terminating the contract. So we wanted to proceed with it. We wanted to provide them with opportunities so that they can mend themselves. That's why the NOC was provided.
Duly noted. Your time is over. Thank you so much.
Thank you. Thank you, Arbitrator.
And now I would request the respondent counsel to conduct cross-examination of this BEPSA witness.
Honorable Arbitrator, before I proceed with my cross-examination, I would like to give an objection on the fact that witness has stated right now that they didn't get the information about account freeze or the account status of Fiscal before giving us the NOC. But it was clear that on 1st February 2021, we have sent them a mail letting them know about our account status. And on 27 February 2021, they have—
Which document are you referring to, Learned Counsel?
Our exhibit number 4.
Please refer to page number.
Honorable Arbitrator, page number 26, exhibit 4.
That's a mail from Azan Rahman to Ananda Pathak.
Yes, the person responsible for BEPSA, the project director.
The mail is dated 1st of February 2021.
Exactly, Honorable Arbitrator. And they have issued us the NOC on 27th February.
Okay. After, on 27th of February.
Right.
You now conduct your cross-examination, please.
Thank you. How long have you been in BEPSA?
I have worked in BEPSA for more than 20 years, around 22 years.
And why did BEPSA choose you to be in the position?
Because of my capabilities, compatibilities.
Well, you are all then you are aware of the scenarios and the facts that happen in this company or in this transaction. Well, then I would like to ask for the honorable arbitrator that is BEBZA the only company who with whom you were dealing with the account status, or there were many other company who also had the problem with dues of BEBZA?
Are you asking me the question?
Yes, exactly.
Do I handle, if I got your question right, did you ask that do I handle only BEBZA's account?
No, sorry, I'll come again. That is only BEBZA, the company who didn't pay, is Fiscal the company who didn't pay BEBZA the dues, or there were other companies who were also facing problem with dues?
Counsel, that is not relevant here. I'm sorry.
Okay. Okay, is it common for the companies like sometime that they cannot pay their lease amount on time? Is it common for other companies? As you are an experienced person, is it common for the companies?
Yes, that's common.
And
not fairly common, but that is common.
Okay, and you are aware of the Fiscal's bank status?
In which way? I mentioned that our company received the information on Fiscal's account being frozen in February.
And despite of having the knowledge of account status of Fiscal, you have sent them the NOC, right?
The conditional NOC, yes.
Yes, despite of having the knowledge of Fiscal's account. And why did you terminate Fiscal all of a sudden?
It was not all of a sudden. There were continuous default made on part of the Fiscal, and they were not only the breach of NOC conditions, but they were also breach of the lease agreement itself. Okay,
and did you give them any letter or any notice before termination or before auction?
Counsel, the NOC itself acted as a constructive notice.
Well, as a renowned organization, wasn't it appropriate for the final notice before termination or final notice at least before auction, as Fiscal didn't get any final notice before termination and before auction, either of them?
Well, formalities and legal requirements are not the same, I believe, Counsel. So there are no breach of legal duties on the part of us. That I can assure you.
Okay, but as if I say that you as a company before auction, you should give a security clearance to Fiscal before auctioning the property. But I have but Fiscal didn't receive any security clearance even before auction. There were no security clearance because as BEBZA, as Fiscal was holding the asset for long time, so they had some valuable things, goods in their asset. But your company haven't issued any security clearance.
Counsel, can you please mention that whether Fiscal had applied for the security clearance?
Well, isn't it responsible for the BEBZA before auctioning the property for the security clearance? Because the position was...
Let me tell you this, Counsel. I hope that will answer your question. The auction was done according to BEBZA rules and the BEBZA Act 1980. So all requirements were made.
Well, but
we didn't think about just formality.
But there were no security clearance, right? There were no. I didn't receive any security clearance in your exhibits. Fiscal didn't receive any security clearance from BEBZA.
May I intervene?
Yes.
You were saying that no notice was served on the respondent at the time of termination of the lease. Am I correct?
Can you come again? Sorry.
You are saying that no notice from the side of BEBZA has been served on you before terminating the lease. Am I correct?
There was no prior notice
served on you
auctioning
by BEBZA.
By BEBZA, yes. Neither we got any notice before termination, neither we got any notice before auctioning even. And moreover, we didn't get any clearance security notice that
Let
as
me finish,
our belongings
let me
were on
finish,
our account.
Learned Council, you'll get the chance. So like you are saying that the termination earlier stated that as well. Now you have also stated that. Am I correct?
Yes, yes.
Have you challenged the legality of the termination?
Yes, I can also challenge the legality of termination, as BIBSA was well aware of the bank status. Moreover, they didn't terminate, they didn't give any notice before termination. Moreover, I would like to grab your attention that on 20th November, they have published the auction, which means that within 35 days, they have just auctioned the property. And according to the legal transactions or normal
Learned Council, have you taken any step regarding that?
well, we didn't take any step, but we are thinking of taking a legal action after we have completed one dispute. The dispute between capital, we will take a legal action against BIBSA, as BIBSA is our not direct client, direct dispute matter right now. But BIBSA have also breached.
When the lease was terminated?
The lease was terminated on
15 July 2022.
Yeah, 15 July 2022.
Yet you haven't taken any action regarding that, but you are saying that this termination has been illegal.
As there is an ongoing yes, as there is an ongoing dispute going on. Moreover, because of the COVID pandemic situation that everyone faced, we couldn't take any action that time.
You can ask your final question to the witness. You have just got 1 minute.
Who is responsible? Who is responsible for the valuable products or assets that was in the property of fiscal? 6,500 pairs of shoes and other construction material. Who is responsible? And the furniture and the machineries, who is responsible?
As per my knowledge, that factor would be handled by BEBSA rules, BEBSA Act, and lease agreement between BEBSA and Fiscal Sense Limited.
Well, I was aware that you were expert. You were expert in your position, and you could answer you can answer the question what I am asking right now. That as there was no legal termination, no auction, and for your for your bad faith today, Fiscal is now in his position right now. For the bad faith of Fiscal, for the bad faith of BEBSA and Capital, today Fiscal is now in his position. So who will be responsible for Fiscal's assets, belongings on their property?
I am afraid that I would have to intervene now. The time is up. I would now ask the respondent to make their opening statement. And who will make the opening statement for the respondent? I believe that the claimant side is done, right? Am I correct?
Yes, Honorable Arbitrator.
Yes, Honorable Arbitrator.
Okay.
Am I audible?
Who will place the opening statement for the respondent?
Honorable Arbitrator, this is Maliha Mumtaz. I'm representing North South University, and I'll be speaking on behalf of the respondent Fiscal Sense Limited.
Okay, Learned Counsel, one of your counsel stated during the cross-examination that he has got some points to make, and he wanted some time for that. So if you would like to clarify anything regarding that, you can make that point now, and then you can proceed with your opening statement. You will get 10 minutes. It's 4:18 now. You will have to conclude within 4:28.
Honorable Arbitrator, I don't get your question. Could you please say it again?
At the time of the cross-examination, your counsel said that he needed some time more, which I couldn't give to him. If you would like to say anything respecting that cross-examination, you can just say it now, and then within 10 minutes. We'll have to complete within 4:29.
Okay. Much obliged, Honorable Arbitrator. My
You
question
are
is,
echoing. Learned counsel, you're echoing. Your device is echoing. There is an echo.
now it's okay.
Yes, it's fine. Please proceed.
My question is the first witness of claiming party is here. Okay. I'll proceed with my argument. Indemnity signed by MD of fiscal was a personal capacity or as a company. So how is there anyone?
Learned counsel, you can proceed. I can hear you. Learned counsel, can you hear me? Can everyone else can hear me?
Yes, Honorable Arbitrator, we
Yes,
can.
Honorable Arbitrator.
Learned counsel for the respondent, can you hear me?
Am I audible, Honorable Arbitrator?
Can you hear me?
Yeah, now I can. Okay.
Please, while making the opening statement, please bear in mind that both sides have raised some very particular issues regarding the termination of the lease, regarding the accounts being frozen, regarding breach of contract. So there are just 2 or 3 issues right now. So you need not go into details regarding the other issues which have not been raised.
Honorable Arbitrator, there's question raised, and the answer is Article 8.2. There is breach of contract happened, and that's why we claim that thing. There is 8.2 obligation of 6 months, and we getting not that much time. So it's a clearly breach of contract.
Why it is stated that you are supposed to get 6 months?
Hello?
Why it is stated in the documents that you are entitled to get 6 months to rectify the payment of lease?
In that fact, they're mentioned, and we followed that fact, and we're claiming we're answered the facts.
What is the document that you're referring to, that you are entitled to 6 months?
Sorry?
Are you saying that you are entitled to 6 months before rectifying the mistake or before the termination of the lease happened? Am I correct?
Yes.
Where is the document that gives you the 6 months period?
Okay. 6 month termination period was mentioned there. 8.2.
Please refer to the document, to the relevant page.
Yes. Page number. Page 3
Page 3 of
the argument.
what does it say? What does it say?
Deed agreement.
What does it say?
What does it say?
Yes, it said in Article 8.2, the termination of notice.
In 8.2, termination shall not relieve the parties of obligation that by their nature should survive such termination, including without limitations, warranties, remedies, promises of indemnity, and confidentiality of the parties shall amicably settle and carry out such obligation within a period of 6 months, preferably upon termination and cancellation etc. And as per the deed of agreement, we based on the deed of agreement, we claim the tax.
Please proceed. Yes. Please proceed. Please proceed.
Our team consists of 4 members. Maliha Mumtaz, Maliha Mumtaz will bring the opening statement and will be present examination of chief of the witness managing director of Citibank, Mr. Mahfuz Rahman. My other teammate, Punota Nancy, will be present the examination of chief of the witness managing director of Fiscal Sense Limited, and my teammate Wasi Parvez Tasim will be presenting the cross examination, and our another teammate Saiful Islam Rakib will be presenting as both witness. And lastly, Punata Nancy will be present the closing statement. Now, may I have your permission to start my opening statement, Honorable Arbitrator?
Please. Yes, please.
Much obliged. I briefly represent the summary of the case, deed of agreement between Fiscal Sense Limited Company and Capital Connection Co. Limited Company on 3rd September 2021 is the source of the dispute. The assets specified.
Counsel, I have got a grasp of the issues raised. You have cited Article 8.2 of the deed of agreement. How does that help you?
As per the time they mentioned, and they are they did not fulfill the time duration, and they took their decision. I think these are against with their commitment, and that's why we are hearing the facts.
Okay,
Honorable
please
Arbitrator.
proceed. Yes, please proceed. Yes.
Okay. So Capital Connection Co. Limited and Fiscal Sense Limited agreed in an exchange for a lease property. However, Capital Connections Co. Limited had full knowledge that Fiscal Bank account was frozen. Moreover, Capital Connections Co. Limited had full knowledge about the termination of the lease among BEBSA and Fiscal. On the other hand, on application of Fiscal Sense, the respondent for no objection certificate, which is called NOC, BEBSA imposed some conditions.
Learned counsel, you are saying that the accounts were frozen, and
Yes.
And Capital did have full knowledge of that. How does that help your case?
Because they know about our financial statement and they came to an agreement, then they imposed a claimant for this against Fiscal Sense Limited. So I think that's why we have to bring it here.
Yes, but
This
have you
clause
looked
is
into
very important
the
to
term
mention.
of the NOC? Have you looked into the term of the NOC? It says that the Fiscal Sense shall clear all outstanding dues of BEBSA. And it also says that the required customs formalities must be observed by seller and purchaser and customs clearance. I'm not getting, how does that help you?
For frozen account, we don't have our money was frozen, so we could not pay the bill during at the time. And for custom bond office their demands, illegal demands, we stuck in a position where we have to take this position. We're facing this position.
Okay, thank you so much. Just briefly tell me, your accounts were frozen in 2018, right?
Yes.
How could you receive the installment after that, given the fact that your accounts were frozen?
Frozen. When our account frozen, we could not take it away, take it out our money, and that's why we consulted the bank, and
Okay. Thank you so much. It's 4:29. I will now request the respondent to present their first witness.
Honorable Arbitrator, may I proceed now?
No, your time is over, I'm afraid. I will request the respondent side to present their first witness.
Okay, much obliged. Now I would like to call our first counsel, Punota Nancy, to proceed with her examination chief on Mr. Azan Rahman, Managing Director of Fiscal Science Limited.
Good afternoon, Honorable Arbitrator. I'm Punota Nancy, and I would like to examine Mr. Azan Rahman, MD of Fiscal Sense Company. May I proceed with my examination?
Yes, before we proceed, learned counsel, I'll just I'll just request you to focus on these factors that I have raised. How does that help you? How does that help you? The fact that your accounts were frozen, number one. And number two, even though your accounts were frozen, you still received payment from capital. So I would like to know the practice, the bank practice. When your accounts are frozen, can you receive amount in that account, but you cannot release amount from that account? Is that the practice, or does it work like this in practice?
Sure. I will focus on your points, Honorable Arbitrator. May I proceed now?
Yes, yes. And you need not focus on other aspects. The aspects that I have just said, try to focus on this.
Good afternoon, Mr. Azan Rahman. Am I audible?
Yes.
Could you please mention your name and occupation to the tribunal?
Am I audible to the Honorable Counsel?
Yes, you are.
My name is Azan Rahman. I'm 45 years old, and I'm the Managing Director of Fiscal Sense Limited.
Okay. How long you have been working for Fiscal Sense Limited?
I have been working for Fiscal Sense Limited as an MD for 15 years.
Okay. Could you please elaborate on the service your company provides?
Basically, our company is based on export-import business.
Okay, please tell us about the relationship between your company and Capital Connection Company.
In the capacity of representative of a Fiscal Sense Limited, I entered into a contract on 3rd September 2021, Capital Connection Company Limited.
Okay, did you give any notice to the Capital Connection Company regarding your company's account freezing?
Yes, on December 31, 2020, I sent a mail to Capital Connection Company Limited to tell about the issue that our company's account was frozen by the CBC illegally. They actually demand illegal money from our account. That's why we already given notice.
Okay, what was their response regarding the account freeze of your company?
Before making the deed of the agreement by Capital Connection Company Limited, they knew about our account status, so they confirmed that they have no problem making a deal on that lease property.
Okay, did BEBSA have prior knowledge about the account status before issuing NOC?
Yes, definitely. BIAC knew about our account status before issuing NOC. We applied for NOC on 11 January 2021, and BIAC. Hello.
I'm having trouble in listening to you. There are echoes, and you both are frozen. Now I can see you. Yes, yes. Yes, please proceed. And Mr. Azan, my question to you from the panel is, what step did you take to remove this freezing status of your account?
Actually, CBC demand illegally from our account. That's why we are already ongoing procedure, and our account was frozen till 2018. We are already noticed that we are in trouble. Our account was frozen, and we are still ongoing dispute.
Well, what steps have you taken to unfreeze your account?
Can you repeat the question, Honorable?
What steps have you taken to unfreeze your account?
The account was freeze. This dispute is ongoing. That's why we are not. We are still trying to freeze that, unfreeze that account.
Was the procedure to unfreeze the accounts?
Am I audible, Honorable?
Yes.
Can you repeat it, please? I'm extremely sorry for the technical problem.
Was the procedure for unfreezing the account? What do you have to do?
The freeze, the ongoing dispute is ongoing till 2018, and December 23, 2020, the dispute is dissolved. That's why we are response to the Capital Connection Company Limited to dissolve this dispute by BIAC.
Honorable Arbitrator,
you can proceed. Counsel, you can proceed.
Honorable Arbitrator, may I object on one point on behalf of the Claimant Counsel?
What's the point?
Honorable Arbitrator, the point is that there is no exhibit or any evidence in their written submission regarding any proceedings that they undertook to resolve the bank account issue. So what we feel is that the witness is going beyond their written submission in this regard. There is no exhibits that they have added or any written submission, substantive part, where they have stated or any proceedings that they have undertook to resolve this issue during the entire period. Thank you, Honorable Arbitrator.
Point noted. Learned Counsel.
Can I, Honorable Arbitrator?
Learned
Yes, Honorable Arbitrator.
The other side has raised this issue that you are going beyond your statement of defense. Your witness is going beyond his statement of defense. Is it correct?
No, Honorable Arbitrator. We are trying to fix the issue, and we have already talked to the CBC officer, but at first he asked for illegal money, and we did not agree to the fact that we did not agree to pay the illegal money. We were trying our best to solve the issue that was going with the CBC. And on 23rd March 23, Capital and BEBSA had knowledge that custom bond officer illegally demanded the money.
Where have you mentioned this in your statement of defense?
We have a screenshot in our exhibits. We have given in page 37.
Honorable Arbitrator.
I have taken note because we have got a time frame.
Thank you, Honorable.
Yes. Much obliged. May I proceed with my questions?
Yes, please.
Okay. Mr. Azan Rahman?
Yes, I'm here.
Did BEBSA have prior knowledge about your account status before issuing NOC?
Yes, definitely. BEBSA knew about our account status before issuing NOC. We applied for NOC on 11 January 2021, and BEBSA issued its NOC on 27 February 2021. We already sent a mail to BEBSA to inform that our bank account was illegally frozen by CBC on 1st February 2021. So BEBSA had prior knowledge about our account status.
Okay, why did your company fail to fulfill the conditions provided by BEBSA?
Can you repeat it, Counsel?
I said why your company failed to fulfill BEBSA's condition. Can you just say it again?
As I said before, the reason was our account status and COVID-19 pandemic.
Okay. Did you get any lease termination notice from BEBSA?
No, we didn't get any termination notice from BEBSA.
Did BEBSA breach the contractual obligation with your company?
Yes, definitely. They did. They should have provided a 60 days prior notice for the termination of the lease.
Okay, now shortly answer some of my question. When did your company get the default notice from the claimant party?
On this 12 December 2021.
How much time did they give you to respond to their default notice?
Actually, they gave us 15 days.
Okay, just tell me one thing. Did you have time to fulfill your requirements given by the claimant, or they just issued the default notice before the time is over?
Learned counsel, there is an echo on a constant basis from your device.
I'm sorry for the technical glitch, Honorable Arbitrator. May I repeat the question again?
Again, there is an echo. You can repeat.
Hello?
You can repeat. Yes, yes.
Okay. Azan Rahman, Mr. Azan Rahman.
Yes. Am I audible? Honorable
Okay.
Counsel?
Did the claimant party give the default notice before the time of handover date was over, or they just gave you the notice before the deadline?
Can you repeat it, Counsel? I can hear you fully.
Okay, Mr. Azan Rahman,
I'm
just
afraid.
tell me one.
I'm afraid I'll have to intervene. Time is over for the first witness. Learned counsel, there are problems. There are technical problems from your side. Try to fix that. And if you have anything to add up, you can add it up during the second chief. I will now request the claimant side to conduct cross-examination of this witness. It's 4:41, and you'll have time up until 4:51.
Much obliged, Honorable Arbitrator. Mr. Azan Rahman, can you hear me? Mr. Azan Rahman, can you hear me?
Yes, I'm here.
How are you doing today?
Well, good.
So, Mr. Rahman, I have a very simple question for you. Tell me, is murder a crime in Bangladesh?
Yes, definitely, but it totally depends on if the self-defense, then it totally depends on the judgment or something on the fact.
Okay, do you think can anybody commit reasonable murders?
It totally depends on the fact. I can give any judgment or opinion.
Okay, then for your knowledge, both offering and both murder is crime in Bangladesh. So as per your knowledge, tell me, is bribery a crime in Bangladesh?
Definitely.
Okay, as you ready to know, I'm adding one more information. Both offering and accepting bribery is an offense under section 171B of the Penal Code 1860. Now tell me, then why did you negotiate for reasonable bribery with the anonymous custom bond officer?
Can you clearly read out the screenshot, Honorable Counsel?
Yes, Honorable Arbitrator, the Council would like to draw your kind attention to Respondent's Exhibit number 10, page 38. They added a WhatsApp screenshot. This witness, Mr. Azan Rahman, is clearly engaged in criminal activity because in their screenshot, they tried to bargain the amount of bribery. They said that the amount is not reasonable for them. That means if it would have been reasonable, they would pay the bribery. Although criminal matters are not within the scope of arbitration proceedings, we found it necessary to raise the issue due to the principle of equity being a significant concern here. Those who seek equity must come with clean hands, and given Mr. Rahman's engagement in bribery indicates bad faith from the very beginning. Mr. Rahman.
Can I answer you about this screenshot?
Yes, please.
If I am taking bribe or negotiate to the CBC. So why I'm adding this screenshot on this as an exhibit? If I'm taking the bribe,
This is definitely
you
our
have to
question, Mr.
understand
Rahman,
the
because
reasonable consider. So if I'm taking bribe from the or negotiate the CBC, so why I'm adding that? I just added this screenshot that CBC demand illegally money from us. That's why we are adding this conversation.
Mr. Rahman, let me clear you. You're not getting bribe, you are giving bribe. Secondly, in your screenshot, you have mentioned this amount is not reasonable for you. You should have said that we will not bribe. We will not do bribe. That should have been the statement, but you try to negotiate the amount. Okay, let's move on to the next question. Mr. Rahman, you have paid 60% advance. Did you?
Can you repeat it?
You have paid 60% advance. The capital connections have paid to the capital connections.
Yes.
Okay, where is that money right now?
Our account that was totally freezed by CBC illegally.
Okay, but Mr. Rahman, according to your Exhibit 9, in your account, no money can be deposited. In a frozen account, no money can be deposited, right? Since while it was frozen
according
for
to the bank practice, I know that the anyone can deposit deposit the money for freeze account, but you can debit it. You have to you just credit the money from bank account, but you can debit it if the account is still frozen.
I'll have to intervene. I have a question for the respondent side. You'll have to clarify during the second witness or during this witness the aspect of this particular issue. In a frozen account, can you just credit and you cannot debit? And you'll have to give reference to that if that's your case. And for the claimant side, I would like to ask you one question. During the chief, you have raised the issue that the defendant is going beyond the statement of defense. Do you still have that ground?
Yes, Honorable Arbitrator, because as far our knowledge, they should have been informed about the frozen account while the negotiations or initial deposits were going on, not after that.
We are already informed that our account before going to the deed agreement, we already informed in sending mail to the capital connection on 31 December 2020.
Okay.
When we were in primary
please continue. Yes.
Much obliged, Honorable Arbitrator. Mr. Rahman.
Yes.
You gave the indemnity to Capital Connections Company in your personal capacity. Am I correct?
Yes.
As you are accepting, based on your response, I have a hypothetical question for you. If the tribunal today declares award in favor of the claimant, are you prepared to pay back the 60% advance from your personal property?
Can you ask me the type of hypothetical question? Do you have write this type of hypothetical on cross examination?
Okay, forget about the hypothetical one. Just answer me. As you have gave indemnity in your personal capacity, are you taking the blame now that you can you pay the 60% amount because you have given the indemnity in your personal capacity and not as the managing director?
I will pay. I'm serving the Fiscal Sense Limited for 15 years. So if I have a good faith, I'm eligible to pay the 60% payment as a reputed for the Fiscal Sense Limited.
Honorable Arbitrator, this is a very unique situation where witness took the liability over him to pay the 60% amount. In such case, Mr. Rahman, can you say that your counsels became hostile against you? Anyway, let me proceed. Mr. Rahman.
Can you repeat it? There is a technical glitch, so I can't hear you properly. Can you repeat it, the question?
There is no question for you. I was giving a note to the arbitrator. We're moving on to the next question. Mr. Rahman, in Article 6.1 of the agreement, both you and we agreed to supersede and cancel previous understanding, including your personal indemnity letter. Why this tribunal should treat your indemnity letter as still enforceable? Can you explain?
Can you repeat it, Honorable Counsel? I can't hear you properly.
Honorable
hello?
Arbitrator,
Hello?
the Honorable
Hello?
Arbitrator, hello, can you hear me
Hello?
now?
Hello?
I can hear
Am I
you.
audible?
Can you hear me now?
Yes, yes.
So, Mr. Rahman, my question was to you in Article 6.1 of the agreement, both you and we agreed to supersede and cancel previous understanding, including the indemnity letter. Why
Yes.
this tribunal should treat your indemnity letter as still enforceable? Can you explain that?
I'm afraid that time is over.
Honorable
So
Arbitrator,
far-
I have one last question for the witness.
Yes, please. Please make it fast. You have just like 30 seconds. Yes.
Okay. Honorable Arbitrator?
Yes.
30 seconds for me, right?
Yes.
Mr. Rahman, can you hear me? In your Exhibit 2, Mr. Rahman, in your Exhibit 2, you have attached the application of the NOC, right?
Yes, yes.
Then why did you mention events from September of your agreement in the NOC? But the NOC was on January 11, 2021. How September come before January in a year? Can you clarify, Mr. Rahman?
I think it's just a technical problem. I don't even saw it.
Which page are you referring to, Counsel?
Exhibit 2. Exhibit 2 of the respondent submission.
Page number?
Page number 23.
Yes, your question is.
In first para, they have mentioned events. Events from September, 3rd September 2021 in the NOC, and the NOC was on January 11, 2021.
Yes, I have seen that. And
Why events from September are being mentioned earlier in the timeline? That was my question, Honorable Arbitrator.
Honored Counsel, I have taken note of that. I'm afraid that time is over for you.
Much obliged, Honorable Arbitrator.
Now, I will request the respondent side to call the second witness. But before that, I have got something to say. I will take a break for 10 minutes for the purpose of prayer. Have you heard me? 10 to 15
Yes,
minutes.
Honorable Arbitrator, we'll wait for you.
Yeah, so it's now 4:52, so I am taking a break for 10 to 15 minutes for the purpose of prayer, and then I'll come back. And then what will happen is the respondent side will present their second witness, conduct the chief, and then the claimant will conduct cross-examination, and then the closing remarks will start. Okay. Do you have any question?
No questions, Honorable Arbitrator.
Meanwhile, I have something to say to the respondent side. Your network connection has been consistently very poor. Try to fix that.
My apology, Honorable Arbitrator. We're trying to fix the network issue.
Thank you so much.
Much obliged.
Proceedings adjourned. Can everyone hear me?
Yes, Honorable Arbitrator, we can hear you.
Can I ask the respondent side to present their second witness, please? Can the respondent side hear me as well?
Yes,
Am I audible?
Honorable.
I am requesting the respondent side to present their second witness. It's 5:10. You'll get 10 minutes till 5:20 to complete the chief.
Okay. Much obliged, Honorable Arbitrator. Now I would like to call Mr. Mahfuz Rahman, Managing Director of Citibank.
Yes, am I audible to Honorable Counsel?
Yes.
Yes, you are. So, Mr. Mahfuz Rahman, a very good afternoon.
Good afternoon.
Would you please introduce yourself?
My name is Mahfuz Rahman and I'm the MD of Citibank.
How long have you been working for Citibank? Can you please tell us?
I have been working for Citibank probably 10 years, for 10 years.
How long has your bank been dealing with the Fiscal Sense company?
I have been dealing with Fiscal Sense Limited since 2016 as Fiscal Sense Limited entered our loan agreement with our bank.
What was their position regarding the repayment schedule outlined in the loan agreement? Can you please tell us?
Fiscal Sense has a commendable reputation in the business community. Our decision to extend a loan to them was based on through assessment of their financial standing, credit worthiness, overall business track record. Their reputation within the industry was a positive factor in our evaluation process. Fiscal Sense Limited has consistently adhered to the repayment schedule outlined in the loan agreement. Their financial standing and commitment to meeting repayment obligation have contributed to the smooth functioning of our banking relationship. As the managing director, I have been periodically updated on the status of the Fiscal Sense Limited loan amount. Our communication channels have been remain open and any concern or queries from the company have been promptly addressed.
Do you know Mr. Azan Rahman personally?
Yes, Counsel, I know. I have known Mr. Azan Rahman for a long time. We have a good understanding between us as their company, quite reputation. He has a good image.
Okay, did Azan Rahman communicate about the ongoing agreement with Capital Connections Company Limited with you? Could you please tell us?
Yes, he did it.
Okay. Mr. Mahfouz, can you tell us the reason why Fiscal Sense Limited company's account was freezing? What's the
Um, Bangladesh Bank sent us an official notice to freeze the account of Fiscal Sense Limited without stating the reason. However, as I had a personal term, Azan Rahman informed me about the illegal action taken by CBC. If I am not sure, they said Mr. Azan Rahman said that the CBC illegally demand money on that reason.
what do you know about the Azan Rahman's family condition? Are you aware about it?
Yes, Counsel. I know him personally. During the COVID-19 situation, when pandemic outbreak, Mr. Azan Rahman's wife passed away, and the entire family was affected by COVID-19.
Okay, um, Did you have any idea of the payment which were supposed to made by Fiscal Sense Limited? Can you tell us?
Yes, I was informed about the payment because I have a close relationship with Mr. Azan Rahman. Mr. Azan Rahman told me that if the account activates again, then they will make payment to the BIPSA to fulfill the condition of getting NOC, and also said that they will be getting another payment from Capital Connection Company Limited due to 40% payment.
Okay, Mr. Mahfuz Rahman, Honorable Arbitrator, I have already asked him what I want to know. So
Learned counsel for the respondent, if I may ask some questions to you. You have received 60% of the payment from the other side, right?
yes,
Okay, and there are dues on the part of BEPSA from your side. Is that right? Okay.
yes, Mr. Azan Rahman said this.
Okay. Was the amount which is due to BEPSA on account of the lease terms?
It's not exactly mentioned in the facts.
Okay. What I'm trying to understand is like, is that amount lesser or greater than that 60% advance amount?
Honorable
shed-
Arbitrator, lesser. It's lesser.
It's lesser.
Yeah.
So what I'm trying to understand is like, the advance amount that you have received from the claimant is greater than the dues that remains due with BEPSA, right?
Yes. If you get money, we'll provide these things to the claimant.
Okay. I'm just asking about the 60% amount. I'm just curious about that amount being lesser or greater than the dues that remains due with BEPSA.
Honorable Arbitrator, could you please say it again?
Yes, my question is very simple. Is the advance amount, that 60% advance amount, lesser or greater than the amount which remains due with BEPSA?
Honorable Arbitrator, it's lesser.
Thank you. And you are done with your chief, right?
Yes, Honorable Arbitrator.
And now I will request the claimant's counsel to conduct cross-examination. It's 5:17. You have to conclude within 5:27.
Honorable Arbitrator, may I have your permission to invite Ms. Zareen for the cross-examination of the second witness, Mr. Mahfuz Rahman, please.
Much obliged, Honorable Arbitrator. Mr. Mahfuz, am I audible to you?
Yes, am I audible to you?
Yes, but I can't see your face. Yes,
Now,
right now it's fine.
okay.
Mr. Mahfuz, please state your name and designation for the record purpose, please.
My name is Mahfuz Rahman and I'm the MD of Citibank.
Mr. Mahfuz, was there any withdrawal or deposit or any transaction done on behalf of Fiscal Sense Limited after the accounts were frozen?
No, if the account was frozen, the account, according to the bank practice, only the debit is possible. You can take money from the account, but you can credit the account.
Mr. Mahfuz, I think you have not got my question. Let me rephrase it again. Was there any withdrawal or deposit, anything done on behalf of Fiscal Sense Limited after the accounts were frozen?
Can you repeat it? I'm not understanding your question. It's from my mistake. Please, can you?
Was there any withdrawal or deposit after the accounts were frozen?
No, no.
In that case, Honorable Arbitrator, he is contradicting the first witness, Mr. Azan Rahman, because Mr. Azan Rahman in his examination in chief clearly stated that Fiscal had deposited the checks to this bank. Mr. Mahfouz, my next question to you is, I want to share something to you.
Learned counsel, is there any documentary evidence supporting the statement that you have just made?
Honorable Arbitrator, Mr. Azan himself has said in his examination in chief that
Yes,
the payments were done.
I have taken note of that. Is there any documentary evidence that you can refer to?
Honorable Arbitrator, the checks were deposited as per the written statement of the respondent's witness.
Okay, can you refer me to any particular page? You can take your time.
Okay,
You can
Honorable Arbitrator.
your cross-examination, and you can take your time. Yes. Please proceed. Please proceed.
Much obliged, Honorable Arbitrator. Honorable Arbitrator, I would like to draw your kind attention. I found it. It's in page number 15 of the respondent's written submission.
Page number 15.
Yes, Honorable Arbitrator. May I proceed?
Yes, yes.
Mr. Mahfouz, am I audible to you now?
Yes.
Can you see my screen? It's your witness statement.
This is my witness.
Okay. So my question is, as per this, in your witness statement, you have clearly mentioned that suddenly a notice came from the Customs Bond Office for freezing the fiscal company's account. Did I read it correct? I mean the highlighted portion.
Yes.
So can you explain from whom you received the notice to freeze accounts? I mean, was that the governor of Bangladesh Bank or the Customs Bond Office? I need a clarification.
Bangladesh governor.
So in that case, you have just misphrased in your written statement. So my next question is, in which year did you retire?
I think it's a printing mistake or typing mistake. I don't know about it. I'm just
Okay,
giving the
so
statement.
you are just contradicting in your written statement and your oral statement. So Mr. Mahfouz, my next question is, in which year did you retire?
Can you repeat it?
In which year did you retire?
In this year, September.
Okay,
September
so
month.
Mr. Mahfouz, as you served as managing director of a bank for quite a long time, you must know the banking practices, right?
Yes.
Okay, can you describe under which grounds a bank account can be frozen?
If we give any notice from the Bangladesh bank or certain higher authority, we don't have any right. We have.
Okay, I got my point. I got my point, Mr. Mahfouz. Mr. Mahfouz, then you must be acquainted or familiar with such situations and must have received many notices like this before, right?
From where?
From Bangladesh Bank to freeze the accounts.
Yes.
Okay, so didn't you feel that the current notice from Bangladesh Bank and the previous ones which you received were faulty?
I can't get your point. Can you repeat it?
Didn't you find that there is any difference between the previous notices and the current notice?
Which notice are you talking about? Can you clear it? Can you make it clear?
Of course, I'm just showing it to you.
Yes.
I would request my co-counsel Rochita if she could open the exhibit 9 of the respondent submission, because right now I can't get it. Rochita, can you help me in this regard? Exhibit number 9 of the respondents council.
One moment.
Okay. In this time, let me ask you some more questions.
Yes, you can.
Mr. Mahfouz, I wanted to ask that didn't you find any difference between the other notices of freezing accounts that came from Bangladesh Bank and the present notice which came to you for freezing the accounts of Fiscal Sense Limited? That was my question.
No, there is no difference. As per the notice, I just temporarily freeze the account. After the dispute was on, then I will
Okay, I got my point,
unfroze.
Mr. Mahfouz. I got my point, Mr. Mahfouz, but according to the legal provision, there must be a legal ground covered under any law of Bangladesh in that notice. But in your notice that you annexed, there is no mention of such law. And as per the notice, the governor signed the letter. Am I right?
Yes.
Mr. Mahfouz, don't you know that as per the existing laws, as well as the banking practices as well, such notices are generally issued by Bangladesh Financial Intelligence Unit, not by the governor by himself. Rather, the deputy governor issues such notice. Didn't you know that?
My co-counsel Zareen, can you see the screen? I have opened Exhibit 9 for you.
Mr. Mahfouz, is the screen open to you?
It just shows that Article 8 termination, nothing else.
Okay, Mr. Mahfouz, let's move to the next question.
Okay.
What I want to focus that the governor himself doesn't sign in such notices to freeze the accounts. As per the existing laws, the deputy governor signs on behalf of the Bangladesh Financial Intelligence Unit. But despite having more than years in such banking practices, you don't know that.
According to your argument, I mean the same. The governor.
I'll have to intervene. The time is up. It's 5:27.
Learned Counsel, I have just one more question, if you allow me to do so.
Just ask that in the form of a suggestion. Don't ask.
Objection, Honorable Arbitrator.
Yes, please.
Arbitrator, we have given enough time for cross-examination, and our respondent team also followed the timing schedule, so we did not accept the time. Cross-examination date timing is not accepted for us.
Okay, learned counsel for the claimant, learned counsel for the respondent has raised an objection. You are 1 minute behind, so you can put your point in the form of a statement during the closing remarks.
Okay, Honorable Arbitrator, much obliged.
Objection upheld. Now I would request the claimant to present their closing remarks.
Honorable Arbitrator, I would like to invite Counsel Mr. Awal for the closing and summation of our submission. May we kindly have your permission?
Yes, please proceed. It's 5:28 and sorry, 5:29. You'll have to conclude within 5:39.
Much obliged, Honorable Arbitrator.
Honorable?
Yes. There is a screen which has been shared, I don't think that is necessary. Yes.
Councillor Zareen, can you stop sharing screen? Am I audible, Honorable Arbitrator?
Yes. Yes.
Thank you, Honorable Arbitrator. Honorable Arbitrator, before I proceed on behalf of the claimant side's closing statement, I would like to make a clarification that in my opening statement, you asked regarding the default notice. I misquoted Article 7.1. It is actually Article 8.1 of the agreement. So I apologize for the inconvenience to you, Honorable Arbitrator. Honorable Arbitrator, in our closing statement, we have 3 points to address. First is to present the core arguments on behalf of the claimant side. Second is to rebut the arguments advanced by the respondent side. And third is the relief that we have sought, to read out the relief. So, Honorable Arbitrator, may I proceed accordingly, or should I skip any of this and present
You can
parts?
proceed.
Thank you, Honorable Arbitrator. Coming to the first portion of presenting our core argument, Honorable Arbitrator, it is that the claimant humbly submits that we abided by the agreement in its entirety, in good faith, and urged the respondent to perform their obligations. Our counsel, Zareen, have attempted to prove this through our witness, Mr. Anthony. Sir, until the claimant was compelled to terminate the agreement due to the respondent's breaches, they were yet to deliver, whereas the actual deadline was December 2021. And another point of argument is that, Honorable Arbitrator, is that the respondent, they were active in so many areas, including accepting advances from us, making empty promises to us, obtaining NOC from BEPSA, etc. All their activity stopped when it came to resolving this alleged account seizure, which again was paralyzing their actual performance of the agreement. It is as if the respondent was doing everything that is required to enrich themselves, except the actual thing which would have enabled them to perform the obligations under the agreement. Now, Honorable Arbitrator, before I read out before I go for the rebuttals point, I would like to also point out another thing, that our agreement with the respondent is actually Tier 2, Phase 2 agreement. It's founded upon another agreement, the agreement between BEPSA and the respondent, the lease agreement, which they signed on 2013. So if when BEPSA terminated their agreement with the respondent in 15 July 2022, this itself ipso facto makes the respondent impossible to perform or deliver the obligations that they made with us. So it was very reasonable for us to terminate the contract, because they do not have the lease from BEPSA right now. So how can they give prior right to us of that same lease? Coming to the points of rebuttal, Honorable Arbitrator, we have 5 points of rebuttal. Firstly, regarding their claim that we had knowledge about the account seizure. Honorable Arbitrator, we have not denied anywhere that we had no knowledge of the account seizure. But the points that need to be mentioned here to focus is that they informed this after the signing of MOU, and we initiated the advance payment. Another point is, Honorable Arbitrator, that the account was seized in 2018, 12th December, if I'm not incorrect. And this is they did not deny that, but they informed this after signing MOU, after the ending of negotiation, after the initiation of our advance payment on 31st December 2022, which again shows bad faith from their end. Thirdly, this account seizure concerned more the respondent than us. It is their account which was allegedly seized by the alleged CBC official, again through a faulty notice by this governor of Bangladesh, who never issues such notices. But without addressing this issue, without addressing this issue through a proper channel, what they did was they made an agreement with us. They agreed in Article 4.1 of the agreement that within 4 months after signing of the agreement on 3rd September 2021, they would deliver. If they had issues with this account seizure, they should not have made promise in the first place that they would be able to perform and deliver within December 2021, just 4 months' time. They could have negotiated. They did not. Signed, entered into an agreement where still this account was not, a seizure issue was not resolved by them. Yet they made the promise with us and then defaulted. And another thing is that in none of their exhibit, they can show that they have added exhibits which shows that they informed us. But there's no exhibit that shows that they tried to resolve this issue through CBC, except the fact that they indulged in this criminal activity of trying to assure or accept this reasonable bribery. Other than that, there's no official process through CBC or complaining to CBC or going to Bangladesh Bank, challenging this notice, or going to Citibank that this is an illegal or court proceedings. None of this exists in their proceedings. Regarding the deposit, the witness, Mr. Azan Rahman, accepted in cross-examination through my co-counsel Rochita that they have our amount advance paid is frozen in that account. They did put that amount into that account as such frozen. But Honorable Arbitrator, in their Exhibit 9, this faulty notice itself said that there can be no transaction, no withdrawal, no deposit. The three words have been used. None of it can be performed under that account. So we are not clear that an account which is already seized in 2018, in 2020, how can they deposit our advance in that account? And if they did, according to Mr. Azan, who accepted this, then it's clearly bad faith, because they knew that our advance would be stuck there and they would not be able to withdraw that from there. So this is our first point of rebuttal. Second point of rebuttal is that the BEBSA termination issue, that they did not issue notice, or before the auction, they did not issue notice. Honorable Arbitrator, they cannot show any exhibit where they challenge this to BEBSA. They cannot show any exhibit that they challenge through BEBSA's proceeding that BEBSA cannot do these, BEBSA violated the lease agreement. None of this sort. It's just a mere statement that they're making out, which is beyond their submission or beyond the exhibits. Thirdly, regarding 8.2, Article 8.2, we believe, the claimant said, that they have misinterpreted this entire article. This article talks about post-termination period, amicable settlement, not before termination. Under Article 8.1, any party can unilaterally terminate the agreement. After parties terminate unilaterally, the other party can move on, and within 6 months period, they will be able to they should go through an amicable settlement. We have added the Exhibit 25 and Exhibit 29 of our submission, where we made the request for amicable settlement. Our fourth point of rebuttal is regarding the personal indemnity issue. Honorable Arbitrator, in the cross-examination of Mr. Azan, to my co-counsel Rochita, he accepted personal indemnity. Now, this is again a unique situation for us, where this person is ready to pay from his personal property if this tribunal today give verdicts in favor of the claimant. Honorable Arbitrator, the counsel appears from the respondent side has rather been hostile against their own client, presenting him as other, throwing him under the bus kind of situation. Our arbitrator, he could not explain Article 8.6 of the 6.1 of the agreement, where he himself signed and he himself superseded his own personal indemnity, which he issued to us. Again, another thing, Honorable Arbitrator, in our Exhibit 10, we have added the indemnity letter. Yeah, I can refer to it's page 54. In this indemnity letter, he himself said that it is only limited period indemnity letter till the signing of an agreement. We signed the agreement, we added the advance amount in Article 3.1, and in Article 6.1, we superseded all of it together, including him. Right now, he's coming before this tribunal and claiming that this should be, this indemnity should be enforced against him. This is a unique situation. Coming to the point of notice that we issued, default notice of 15 days rather than that of 60 days. Of arbitrator, the notice was issued on 12th December 2021. This notice, yes, there is a requirement under the agreement that 60 days notice has to be issued. But then again, the date was 12th December 2021. By the end of December 2021, they had to perform. Even if you wanted to issue a notice, which would be 60 days period, it would automatically exceed the contractual obligation of performance within December 2021, because only 18 days were left. We gave the highest time that we could give to them, 50 days notice, that is 28th December. So it was reasonable for us to do. Another thing is that the Article 8.1 stated that after issuing notice, if the other party did not cure, then we can terminate by 60 days. We did not terminate by 60 days, within 60 days. We terminated nearly after 1 year, on 15th of July.
Can you hear me?
Yes, Honorable Arbitrator.
You will have to conclude within 1 minute, I'm afraid.
Thank you, Honorable Arbitrator. We have, this was the submission on behalf of the claimant side in our closing. The relief that we have sought, Honorable Arbitrator, is that we feel we have been wronged. And when a party is wronged, there should have a remedy according to the equitable doctrine of why there is a wrong, there is a remedy. We have added our relief that we have sought in our written submissions. And we feel that this honorable tribunal will ensure justice. Justice will prevail through the awards of this tribunal. Thank you, Honorable Arbitrator, for your patience, listening to us. Thank you, everybody. The claimant counsel rests its case here.
Thank you so much. Now I will request the respondent counsel to commence their closing remarks. It's 5:39 and you'll have to conclude by 5:49.
Much obliged, Honorable Arbitrator. At first, the council from the respondent side will be answering some of the propositions given by the claimant, and also I will represent our argument shortly, and then I'll be seeking my reliefs in my closing statement. May I proceed with the closing statement, Honorable Arbitrator?
Yes, please.
Much obliged. Here, following the argument, at first, I want to mention that they said that the issue they bring, that they terminated our deed of agreement before the deadline was over. The deadline was the December 2022, but they terminated our agreement before 18 days. And secondly, they also breached the Article 8.1 and also breached the 8.2 of the deed agreement. As the fiscal sense company from the beginning had a bona fide intention to fulfill their agreement, but they couldn't do it because of the COVID pandemic situation, and also they were having issues of their freezing account. But I want to mention that the claimant had already prior knowledge about the freezing situation. Although having their prior knowledge, why would they enter into a contract with us? Because they also thought that we are able to fix it, and we wanted to fix it as soon as possible, and we have tried our best. We tried to talk to the CBC officer about it, and from the claimants council, they are saying that the Mr. Azan Rahman, who is a very reputed MD of Fiscal Sense Company, was trying to bribe the CBC officer. But do they have any proof? They're just they are just trying to ruin the Mr. Azan Rahman image. They're manipulating our words, and they're making their own statement on absolute, which is absolutely baseless. I would like to mention that I would also mention about their exhibition 4. Exhibit 4, they did not mention any date clearly, and also they said in their exhibit 4 in their they say that they entered they have a meeting on 15 August with our company Fiscal Sense, which is absolutely impossible. How can our meeting can be set in a national mourning day, which is a holiday? This is another issue that I would like you to note. The last the thing I would also like to mention, that the 60% payment. Okay, just give me a time. Okay. Then after termination the agreement, within the following 5 days, they went on the auction called by BEBZA. That clearly indicates their ill motive, that they had a prior communication with BEBZA that they will get this property from a very illegal way. And now they're accusing us for not fulfilling their agreement. This is absolutely baseless. And they did not gave us any prior knowledge about it. And BEBZA also did not give any of the prior notice about the auction. For their illegal auction, we Fiscal Sense Limited faced a huge loss, and the loss is around 3 crore 52 lakh 77 thousand taka, and with 15% interest, the amount is 50 crore 2 lakhs and 53,000 taka. Sorry, I missed it. The amount is 5 crore 2 lakhs 53,000 taka, which is a big loss. Now, now they are rather saying it that they face loss for us. They rather we feel a big loss for them. So Honorable Council, I would like to ensure you that our company fiscal sense did not have any ill motive. Rather, we tried our best to fulfill our agreement with Capital Connection Company. Rather the Capital Connection Company and BEBSA had ill motive, and they for their actions we faced a big loss. So in my and now I want to request before the arbitration tribunal to seek our reliefs. So our first relief is that to declare the respondent is not guilty of breach of contract. My second relief is declared there was no good faith, and there was no good faith and of the claimant, and for their illegal intention we face big loss. Declare BEBSA is also responsible for our loss. And the fourth is declared the respondent is not accountable party at all, but the claimant is the accountable party here, and declared that the claimant party is one to be accounted for. And the last one is that declared the respondent is not negligent and did not perform unfair activities. By saying all this, I want to rest my case here, Honorable Arbitrator. Much Honorable Arbitrator. Hello. Hello. Hello, Honorable Arbitrator.
Yes, please.
I have finished my arguments. I want to rest my case.
Okay, you have got 3 minutes more.
Yeah, I have already asked for my reliefs.
Okay.
Okay.
Thank you so much.
Okay,
My
much
line
obliged.
broke for a while. My line just broke for a while.
Should I repeat my arguments again?
Could you please just say that the last portion of your closing remarks within 1 minute?
Okay, I want to repeat my reliefs that I want the honorable I want that arbitration tribunal to declare that the respondent is not the one who breached the contract. Rather, the claimant is the one who breached the contract. And for their illegal motive, we rather faced a huge loss, which is 5 crore 2 lakhs and 53,000, and now they're again accusing us for their loss. But where is their loss? They had already got their property in an illegal auction, and now they're again blaming us. But where they were when the time as we mentioned in Article 7.1 that we need to, if there is any dispute, we need to fix it through BIAC. When they were but they did not wanted to solve the dispute that time. Rather, they went on an illegal auction, then get the property, and now they are accusing us for paying their money now. And the second thing is that I want the arbitration council to understand and declared that BEBSA is also the one who had ill motive and responsible for the respondent loss. Much obliged, honorable arbitrator. Now the respondent council would like to rest its case here.
Thank you so much.
Thank you, participants from both Thaga University and Northrop University and our honorable arbitrator for this wonderful session. Well, it will take around 5 to 7 minutes to prepare our result. And during this period, we will watch a video on introducing BIAC. Well, now I would like to request all participants from Dhaka University and North South University and our honorable arbitrator to open their video for capturing a photograph. Please, everyone open your video so that we can capture a photo. Please.
Uh, uh, I would like to draw the kind attention of the host. Ma'am, I think the video, turning on the video option is off. My team members cannot turn on their videos.
Okay. We are taking this into consideration. Arbitrator, our honorable arbitrator has taken a prayer break, so we need to wait for him.
Yeah, sure.
Honorable Arbitrator, I would like to request you to open your video so that we can capture a photo. And also, I would like to request all other participants. Honorable Arbitrator. Sir, can you hear me? Honorable Arbitrator, sir, can you hear me, please? So I would like to request everyone to open their video so that we can capture a photo, please. Okay, answer feedback. So now I am handing over the floor again to our honorable arbitrator of the session to provide his valuable feedbacks.
Hi all. Firstly, I will just apologize because like during the proceedings, sometimes I have to intervene, knowing fully well that you are all young people trying to learn. But I believe that the purpose of the moot competition has been that you get a real life experience. That's why I had to intervene. But I will say, like subjectively, you have done really well. I'm talking about both the teams. Obviously, one team will win and one team will lose, but what you will take home is not the result, but the learning experience. Before I provide my feedback, I would like to know whether or not you have got any question that you'd like to ask. You can feel free. The arbitration proceedings has ended. Do you have any question? Either from the, I would again say either from the claimant side or from the respondent side or from DU or from NSU. Do you have any question that you'd like to ask me regarding like anything? You can feel free.
Honorable Arbitrator?
I'm no longer the arbitrator.
Sorry,
Yes.
sir. Sorry, sir. So my question was regarding the opening statement. So we devised an opening statement, prepared it, and then there appeared a sort of difficulty for us to not go through that, but rather according to the requirement in that tribunal. So my question is regarding how to devise an opening statement, focus on what issues, and I mean, what would be appropriate in that case? Thank you, Honorable Arbitrator. Sorry, sir.
The thing is like in real life, what happens is the proceedings entirely depend on the concerned arbitrator. And there is no objective answer to that. I have dealt with quite a number of domestic arbitration from the opening stage till the award stage. I have also been involved with some international arbitration as well. I have advised my clients. It depends a lot as to whether or not the arbitration is ad hoc. If the arbitration is institutional, a lot depends on the institutional rules. If the arbitration is ad hoc, a lot depends on the parties' agreement. You'll have to understand the very basic of arbitration. This is very close to litigation, I will say. And I have also observed that during the proceedings, you have also adopted a litigation style in conducting the proceedings. Another thing is, if you ask someone to sit outside and observe the proceedings and say, after the conclusion of the proceedings, tell me, what do you think? What was that? Was that a litigation or was that an arbitration? I believe that most of the people will not be able to differentiate between these two vital forums. And after seeing your performance, it's not your fault. Again, I'm saying, because when you are performing in an arbitration proceedings, you must have extensive training regarding arbitration, which I believe you didn't have. Most of you didn't have. So for that reason, it became like a litigation thing. And given the time frame that you got, it was really difficult for you as participants to actually deliver the case in the way you actually wanted to. My advice will be towards you, if you go into moot competition, or in the future, hopefully when you'll be in the profession, if you go into the real life arbitration, my advice will be towards you is, particularly for the moot competition, the brief will be very hefty and it will be voluminous. It's very natural for there to be a bulk of papers. And in most of the cases, what will happen is the arbitrator, he will not have any knowledge of the case, and he will try to understand the story from your version. The vital thing to do is to find out the issues, I will say, the matters in dispute. Take them from the papers and try to simplify them. Don't make your case clumsy. Okay, my advice will be towards you. In what happens in the academic world is, when a scholar comes up with a thesis or a claim, he can present it in just a very simple form. Just three things can be noted. Firstly, he provides the context. Secondly, his claim, I claim that, a lawyer says, I submit that. And thirdly, he or she will give the roadmap through which he or she will prove his claim, thesis, or submission. As a lawyer, you can also follow that. Give the context briefly. Just say what you want to say. I claim that, I submit that. Be original. Try to bring out your perspective. Obviously, your perspective will have to align with your client's case. And then you give the judge, the adjudicator, roadmap through which you will prove your submission, your claim. But this is the thing that we apply in our academic life. This is the thing you can also adopt in your practical life as well, because it really helps. Don't try to bring so many issues in 10 minutes. It's not practical. The adjudicator will never want to know every detail of every single event. It's very useful if you just can find out the very basics. of your case, find out the vital areas of dispute, and then focus on those things. It's not wise to go beyond two issues, I would say, when we are actually acting in a world like this. In this instant proceedings, I'm also giving my feedback as well. And at the same time, I'm just trying to give you some of my thoughts as well. In this particular proceedings, NSU suffered respecting their internet connection. That was something that I had to consider, but again, the thing is, it was predetermined that it will be a Zoom session. So it was up to the site to prepare everything so that the connection is smooth, the lines don't glitch, and things like that. But it didn't happen. There have been like events of glitches, echoes, and so on. So I will also advise you, after this COVID pandemic world, what we're seeing is like the international competitions are being arranged virtually as well. So if you're competing in an international platform, it will completely go against you if your internet connection glitches. This is something that you have to bear that in mind. And also in terms of the merits of the case, when I didn't get that much time to go through all the papers, but from my basic perusal of the documents, what I found is the case for the claimant side was strong on merits. However, when I had to adjudicate, I didn't take that into account. I took into account your written submissions, your written pleadings, and your submissions. Obviously, in a virtual world, it's very easy to prepare a script and read that out. But obviously, the adjudicator is not looking for a newsreader; is looking for a counsel. That's why he or she might intervene. What makes arbitration different from lead litigation? I will say it's all about party autonomy. Because this is a product of parties' consent, and both the parties will have to give consent to come to arbitration. The arbitration clause is vitally important. Some of you have raised some very important points that the other side was going beyond their statement of defense or statement of claim, which is vitally important, because obviously in real life, you cannot go beyond your statement of claim or a statement of defense. As a matter of feedback, I will also like to draw some points. Like, for example, when I was going through the statement of defense, I was finding some very basic flaws which should not be in the paper. Like in page 8, at paragraph number 3, it's stated in line number 3, Fiscal Sense Limited canceled the lease illegally after taking NOC from BEBSA. It doesn't make any sense. Then at page number 10 of the statement of defense, paragraph number 6, in the end, it's stated, hence the respondent submits that the claimant has to fulfill the conditions stated in BEBSA NOC. Again, it doesn't make any sense. It doesn't go with the basic structure of the facts. When you write your pleadings in real life, be very careful. I've just read out the basic flaws. There are other flaws as well. In real life, be very careful while preparing your pleading. It's very important. You cannot go beyond that. And when you prepare the witness statement, it's also very important that you cover the basic story within that witness statement. Obviously, when your witness will be orally testified, he can bring some incidental matters. However, it cannot change the basic structure of the written statement that you have submitted already. You know what I mean, right? So you will have to be really careful about these things. And if you would like to build a career in arbitration, or if you would like to develop your practice in this particular area, I will advise from a very early stage, obviously try to attend in the moot competitions. It's a very good way to get engaged in the process. Receive training, which is very important, because in real life, what we are facing, the people who are trying to practice arbitration here, most of the litigation practitioners, they also think that they can practice arbitration only because they know how the litigation works. Honestly speaking, even though litigation has very closer resemblance with arbitration, these two are entirely different concepts. You need not have an arbitration clause to bring a party to the court in the first place. So everything depends on the arbitration clause, and that's the most important part of arbitration. And you can even do a PhD thesis on arbitration clause, on jurisdiction of the arbitral jurisdiction. On the jurisdiction of the arbitral tribunal. So it's very important. And one counsel during the cross-examination raised one issue.